So, uh, you know, estate planning is extremely important. And tonight we're going to focus primarily on the importance of estate planning, living trust, and the various ways to plan for your estate. And in this limited time, I hope to give you a broad overview of various topics that I think are really critical when you're evaluating your estate plan. And then if we have time for another webinar in the future, we'll get into more asset protection topics as well, because they all really tie in. At the very end of this presentation this evening, I will tie in a little bit about the asset protection, how important that is to ensure that it's incorporated into a full estate plan. Now, the reason why I chose this topic and why I think it's so important is that I myself suffered through two poorly drafted estate plans. And the reason I say I suffered through these two poorly drafted estate plans is that both sides of my family were basically torn apart as a result of poor thought put into how to administer your assets. I remember the example of my mother, for example. Her father passed away when she was 10 years old, and all the assets were left to the mother with three lots carved out for my mother and her two sisters. They each received one lot, and this is on the Hood Canal in the state of Washington where I live. Now, this had tremendous sentimental value to my mother, but as a result of my aunt, who through life gained control of my grandmother's finances, she started selling off my grandmother's property and eventually worked her way through to my mother's lot. Now, there wasn't anything to protect my mom's lot for her, other than the fact that it was left to her in a will. It wasn't set up in a trust. It was just stated that I want one lot to go to Connie, my mom. Well, my aunt, she controlled it. She sold it. And as a result of that, a dispute developed between my family and basically my grandmother. My mom had to sue my grandmother, and she did it reluctantly. She brought this lawsuit because she saw it as a way to hopefully wake up my grandmother as to what was going on in her life, that my aunt had taken control and was systematically liquidating all of my grandmother's assets for my aunt's own personal use. My grandmother didn't see it that way. She saw it as a direct attack against her, and she didn't understand why this was being brought. And unfortunately, as a result of that, I missed out on 10 years of knowing my grandmother because of the rift it drove between the family. My mom did win the case, but the win was bittersweet. I remember my mother telling my father that she didn't want to see any of the money that came from that settlement. And she said, I don't care what you do with it. I don't want to know what you do with it. But I'm so upset about this. It wasn't about the money. In fact, my mom would rather just have the lot. And to this day, when she reflects back on it, that is the most important thing to her, was the loss of that piece of property. And I still personally have a problem getting over this area chapter in my life because I missed out on all this time with my grandmother. In fact, when we finally reconciled, my grandmother came out to our house. I remember she was dropped off by a cab, and she was on our doorstep with two suitcases in tow. She moved out of her house. She finally realized what had transpired in her life. I don't know what it was that brought this revelation about, but here I am at 16 years old seeing my grandmother for the first time in 10 years. And unfortunately, she only lived for another 3 weeks after that. And I didn't get to spend any time with her. Now, my mother and her aunt or her sister have since reconciled, but I still harbor hard feelings over that. And that is a problem, that most people do not understand that things like this can occur in life, and that you can do some simple things in your own planning to ensure that that doesn't develop in your family. And so tonight I want to take some time and explain that to you. For those of you that are not familiar with Anderson, have not met me before, we're a law firm. We have two offices, one in Washington State and one in Nevada. We have about 12,000 clients throughout the U.S., and one of the things about us that makes us unique is that we focus strictly on estate planning, business planning. We work with real estate investors, small business owners. We do not engage in any litigation. All of our practice is designed around planning to ensure that people's assets are protected while they're alive, and then when they pass on, those assets will be passed on to their loved ones in an efficient manner. Part of our law firm also comprises a tax practice. Several years ago, I created a tax practice within the firm because I found that most people who go to an attorney run into this problem, that the attorney is unwilling or not knowledgeable regarding taxes, and so they don't discuss it with their clients. They always tell them to go find a CPA to talk about your estate taxes or to talk about income taxes. And so I actually went out and created my own tax practice inside of the firm where we have a top-notch team of CPAs that work with our clients and with other individuals who have not come into the legal side to ensure that they're minimizing their taxes to the greatest extent as possible. And I found that there's this great symbiotic relationship there that our clients find that it works well for them because they don't get conflicting advice. And that's the greatest problem I find when it comes to planning, is finding a team of professionals who are on the same page. We often joke that, you bring 3 attorneys or 4 attorneys into rooms like herding cats because you can't get any of them to agree. Well, we've been pretty successful in our practice and able to bring the CPAs and the attorneys together, and they all tend to agree, although they may have a slightly different take on it, but it's actually always in the best interest of the client. And the last aspect about our firm is that we have a financial planning side where we specialize in certain types of retirement plans, both qualified and non-qualified. So we're a well-rounded firm to work with individuals on all aspects of their planning. So getting into estate planning. Why do estate plans fail? I gave you the example of my mother's plan, or my mother's or her father's plan. And the reason why it failed is because there wasn't any thought put into how to distribute those assets to his daughters, how to ensure that those assets would be protected. And most people, when it comes to planning, always assume that there's plenty of time and that they can just push it off to another day. I can't account for how many times I've received a phone call from an individual who met me speaking somewhere and told me that they need to have an estate plan created within the next 36 hours because they're going to be getting on an airplane and they're concerned about what might happen if the plane went down. Would their children be protected? So we will rapidly put together a Band-Aid to solve this situation, and then it's done with the thought that when they get back from their trip, that they will contact me, and then we will go through in a more comprehensive manner. Probably about 85% of those people, when I contact them, when I know they've returned, tell me, well, we've been thinking about it, we'll get back to you. We know we need to do this in more detail, but we've got other things that have come up, and we'll get back to you when we have time. And that's just a reoccurring theme we see when it comes to estate planning. The other one is poor advice. People are not told all of their different options, the different contingencies that are out there, and how to plan for their estate. So that's always an issue that's involved with estate planning. Poor choice of who you're going to choose as your trustee or your executor to administer your estate. I told you that both sides of my family have been torn apart as a result of poorly drafted estate plans. When my paternal grandmother passed away, she nominated my uncle to serve as the executor of the estate. And true to form, my father, who has treated me as an indentured servant while I lived under his roof and since graduating from law school has put me on permanent retainer for life, told my uncle that I would handle the probate for free in this matter because my grandmother passed away with a will. And I did. I took the case on without a problem. It's family, and I understood that you would do that for family at no charge. But my uncle had different ideas about that. He figured that since he was serving in this capacity and he had the ability to set his own fee, he would charge for his services. So he drug out my grandmother's estate, which was comprised of 2 pieces of property, 5 bank accounts, and numerous personal effects, to 4.5 years, and he charged $75,000 for his time. He was the last person you wanted to be in charge of your estate when you passed away. And in fact, in a conversation with him, I brought up the fact that this was taking too long and he was charging way too much and spending too much money to have items appraised. And his response was, well, how else am I going to learn how to handle an estate? So for the future, when I handle other estates, I'll be better prepared. That's not the type of person you want. Other issues where children don't get along. They may seem like they get along, and as soon as the estate occurs, then the children start fighting, and then as a result of that, your family is torn apart, like the example of my mother. So sibling rivalry is a really big problem when it comes to estate plans, and I would assume that outside of my own practice, from my own experience, that most situations stem from this, that the children are left with a plan and they're left to sort things out on their own. And as a result of that, you have other spouses who exert their influence on your children, and that can result in some serious hard feelings. And then lack of planning for family businesses. People on this call that have created LLCs, corporations, that you have businesses in place, and maybe you have one child who is showing an aptitude for that particular business or an interest in it. But when it comes to your estate plan, you do not plan for that specific business to maybe possibly pass it on to the child that has the most interest in it. And as a result, businesses oftentimes get liquidated for a fraction of what they're worth because the person who is in charge doesn't understand the business. And so these are things that you should focus on in a good estate plan. So here are some notable failures. I'm sure you know who this is. Sonny Bono, an untimely death in a skiing accident in 98. And he died without a will. And it's something nobody will ever know why he didn't ever put together a will. He had a sizable estate. And in addition to leaving a grieving widow who had to head down to the courthouse soon after his death to be appointed the administrator of his estate, who else shows up on the scene? Cher showed up on the scene, and then another person claiming to be a love child surfaced soon thereafter, making the situation even more difficult, where you had multiple people now fighting over his estate because he failed to do anything. And then you had this individual who created a will, but as a result of that, there was serious contest about who is entitled to the benefits of this person's estate. In fact, Michael Jackson's mother in 2009 filed court papers claiming that he died intestate, even though there was a will that was submitted. Because when we admitted this will to probate, you open up a case, you open up a venue for people to claim an interest in it. And so there was a problem here, and this estate generates millions of dollars, and it's still being fought over to this day. And then an even more recent case would be Philip Seymour Hoffman. Here's a case where somebody had a will. He just recently passed away. His estate was valued at $35 million, and he left everything to his oldest child. A portion of it went to his oldest child in a trust, and everything else to his girlfriend, who was the mother of his children. They never got married. Now, in a $35 million estate, between state and federal taxes, you're looking at about $12 million is going to be paid to the government because of the poor planning that went on here. And to top it off, he has two other children that weren't even provided for in his will because they came along after he had executed this will in 2004. So all of this could have simply been avoided had he, A, gotten married, but B, set up a trust of some sort to ensure that all children were taken care of and not just the one that was alive at that time. So these are famous people who have plenty of assets, and they have a lot of time, and they have access to extremely competent attorneys and CPAs, but they haven't put a plan together, and as a result, there was an issues. So what's the plan? Well, the plan typically for a lot of people, unfortunately, is to do nothing. And when I'm talking to you tonight, I'm not just referring to you yourself, because estate planning encompasses more than just you. You're going to find through this call tonight that it also encompasses your children. What have they done? Many times when we talk to our children, we don't think about estate planning from their standpoint, that we only focus on it from our own point of view. Well, they need a plan that should somewhat be congruent with yours so that your wishes and their wishes are carried out and funds do not get diverted to people you may not want money going to if something should happen. So intestacy is the worst thing to be in. That's where you plan, you have nothing, you don't have a will or anything to pass on your estate. You can pass on your estate with contracts, joint ownership, with rights of survivorship. These are the worst ways to handle estate plans. I remember my mother-in-law one time was convincing my wife to sign some documents to make her a joint owner on the account. And I was standing there watching her, and I wasn't even consulted on it. The only time my mother-in-law appears to consult me is when she's created problems and wants me to defend her for free. So this hadn't arisen yet in this particular context. And so finally I got to the gist of what was going on, and I said, hold on a minute. Before Tracy signs that document making her the joint tenant on the account, do you understand that your other daughter then would not be entitled to any of those funds in your bank account, which is essentially all of her life savings? She didn't realize that, and she'd been told to have my wife sign on to her account so she could control the assets if something happened to my mother-in-law. This advice was given to her by a banker, and it was bad advice. Tenants in common are another way. Ownership with spouse. But by far, most people will draft a will. Few people put together living trusts. Now, the problem with the will, of course, if you're not familiar with it, is that it is an orderly way to move assets along to your beneficiaries. And if you don't have it, I had an intestacy slide up here. Let me just skip past this one. If you don't have one, of course, you're going to die intestate. But when you do have one, you're going to end up in probate. Most people don't realize that. They think that if I have a will, I do not have to probate my estate. Well, the fact of the matter is that the only way you can pass on assets that are in your name to your loved ones, if you haven't used joint tenancy or created some type of contractual arrangement like with an IRA where you designate a beneficiary, is to actually open up a probate with the courthouse and submit the will to probate and nominate somebody as your executor. Now, this isn't a simple process. It's a very time-consuming process, and it's a way for attorneys to make money. Now, they may not tell you this when you go down to draft a will. In fact, what I find so discouraging is when I talk to people and I bring up the ideas of estate planning, and I ask them if they have a will, and they say, absolutely, I have a will. My attorney told me I don't need a living trust. Well, I personally feel that when the attorney tells them that, they're banking on the fact that they're going to get that probate when that person passes away. And there's an opportunity there for them to generate fees off of that probate. In fact, my grandfather was an attorney for 50 years, and his practice was comprised probably 50% of drafting wills. And when he was ready to retire, he had an opportunity to take all of these wills that he had in his office, because my grandfather adopted a practice that a lot of attorneys do, and that is to keep your original will on file in their office for safekeeping, of course, not for the sole purpose of requiring your beneficiaries to come back to their office when you've passed so they can pick up the probate, but it's just for safekeeping. Well, when he retired, he sold his practice to his associate. And part of the value in that practice, other than the goodwill, was all of these wills that had yet to have been probated. My grandfather knew what type of return he would get off those probates, and that comprised a fair portion of that sale to his younger associate. So the will, when you pass away, it is a way for attorneys to generate money. I recently had to handle my wife's grandmother's estate. She just passed away this past summer. And of course, I've done things for free for my family, so I was told I have to do things as well for free for my wife's side. And when we handled this probate, I had to actually contact a friend of mine who is an attorney who does a lot of probates, and I had a question on how we could admit this will, because I didn't want to go down to the courthouse itself to admit the will to probate. What I would like to do is send the will in. The problem we had here in this particular case is that we couldn't find a copy of the original will. And what was ironic was that the original will supposedly was left with the attorney who drafted it for safekeeping, but he didn't have a copy. He didn't have the original. All he could produce was a copy. So I wanted to admit it without having to go to the courthouse. And my friend, who's an attorney, the first words out of his mouth was, "Clint, why would you want to do that?" I responded to him that, hey, by submitting the will to probate via mail saves me a lot of time in going from my office to the courthouse. I'd rather not take an hour and a half out of my day to do that if I can just send it in. He said, hey, here's a great opportunity for you to spend 3 hours of billable time when you walk that will in and get it admitted to probate. You're crazy not to do that. Well, he didn't realize I wasn't charging, first off. But second of all, why would I want to do it in any context? Those are the problems that I see from a financial standpoint, is that when you bring an attorney in who makes money off of probate, they're going to do whatever they can to extend it out. If you have property in more than one state, this is a huge issue. Most people don't realize this. When you own property in multiple states, it's comprised as part of your estate, and each property must be probated. Now, what does that mean? Well, if I own property in Florida, I own property in Tennessee, and I own property in Illinois, when I pass away, my beneficiaries will not only have to open a probate in Florida, they'll have to open a probate in Tennessee, and they'll have to open a probate in Illinois as well. So there'd be 3 separate probate filings that would be filed. Many times I joke with people, and I tell them, make sure that you have a Winnebago clause in your will if this is the way your estate is going to be structured. So you tell your family, when I die, go out and buy an RV and plan on a probate wagon, so have somewhere to live as you travel around this country, probating all the real estate that I've forced you to have to go through because I failed to plan properly. Time consuming and expensive. We talked about the expense part, but just time consuming. Once you've opened up in a probate, it's up to the executor to close that estate out. And one of the biggest mistakes that people make is that when they go into their attorney's office who's going to draft them an estate plan, they put together a will, and they're told, you don't need to create a living trust because we will create trust provisions in your will to provide for your minor children if you pass away unexpectedly. Well, the funny thing about probate is that you can create a trust through a will, but as long as that trust is open and paying out to a beneficiary, the probate remains open. And so the attorney can continue to bill your estate until that trust is extinguished. And so that's the last situation you want to find yourself in, is where you've created a trust that just extends open the probate. Another issue you have in some states now, Washington State is one of them. If you nominate somebody as an executor of your estate, that person has to submit to a background check in order to serve. And if certain things come up, such as maybe they had a felony a long time ago, you're aware of it, but you still want them to be the executor of their estate. Well, they're not qualified, and the court will not allow them to be appointed as an executor. So this is an intrusion by the state into your personal affairs because you've opened up the door. You've allowed the camel into the tent by creating a will which must be submitted to probate. They're public record. So anybody and everybody can go down to the courthouse. I mean, I just gave you a couple examples here of 3 famous people. The reason I know about this is because each of these estates were filed in a courthouse which has now become a public record and is available for anybody to see. They're easy to contest. That's another problem we have. There's the example of Sonny Bono. You have people coming in. They can contest how the estate's going to be distributed. So by and large, the will is the last item you should consider when it comes to planning for your estate. Because you lose control over your assets, because you're turning these over to an executor, because there's an attorney involved, because there is a legal process, a system involved that is built around generating billable hours from estate planning, prolonging the process, your best option is to avoid it altogether. And the way you do that is by creating a living trust, which I imagine many of you have done that are on this call tonight. You may have created a living trust already. So I'm going to run through some of those benefits for those of you that have not, just to let you know why this document is so important. So a living trust, think of it as a big box that you create while you're alive, and you put all of your assets into this box. Now, the intent here is that when you get all of your assets into the box, and they're all in there, when you pass away, you give that box to somebody else. And when you give that box to somebody else, well, who you're giving it to is your successor trustee. They're the person who's going to control the disposition, because that box comes with a set of instructions. And it tells the successor trustee how they have to distribute out the assets, when the children are going to receive the money, how the money is going to be received, how to invest it. Well, that process of putting the assets into the box is so essential, because by doing that, putting your assets into that box while you're alive, you avoid probate. The only assets that must go through the probate process are those assets that are left outside of the box. So the example I gave you earlier about having property in Tennessee, Illinois, and Florida, if all 3 of those houses are in your box, not one of them will have to be probated, because your successor trustee, the person who controls that box, will have complete unfettered control over those properties to distribute them to your beneficiaries per the instructions that come along with your living trust, which is the box. Flexibility is built in to a living trust, in that you have many options when it comes to distribution of your assets. You know, I often joke at an example of something early in my career, that somebody came into my office. I'd been practicing for 2 years, and they wanted to leave their estate plan, this lady did, to her cat. She's very moderately wealthy. She had a few $1 million, and in her estate plan we drafted up, the cat was to receive the money in trust. So we held the money in trust for this cat, for its care, and then when the cat died, the estate would be distributed to her son. Well, you can probably imagine what happened. She passed away, and that cat lived probably 9 minutes because the son was aware of it. In fact, when I dealt with the son afterwards, he explained to me that he thought the cat was so heartbroken that it died after his mother did. He failed to mention that it had a size 10 Nike footprint on it, but that might have happened afterwards. He probably stumbled over it after it was already dead. But this is what you can do with a trust. But the idea here is that you have this flexibility. And I mean, I've since dealt with this before. And now, whenever I draft a provision like that, I always put in the trust document that if the animal dies of anything other than natural causes, the remainder beneficiaries are left out of the estate and they're completely skipped. And so if you have any animals that you're concerned about and you want your kids to provide the best care possible, you put a clause like that in there and your cats or your dogs will live very pampered lives after you're gone because those children will be concerned they won't get anything if anything happens to those animals. So you have this type of flexibility when it comes to estate planning inside of a trust. You have it. The benefit of it is that it operates immediately. If something happens to you, you're incapacitated, that trust is there. It's ready to control your assets for you. You don't have to die like you do with a will in order for somebody to take over and gain control of your assets. And so this is often looked at as an alternative to a financial power of attorney that many people have. It's typically part of a comprehensive estate plan. But I explain to people, if you have a living trust in place, you do not need a financial power of attorney if your trust is fully funded because your trust will control all of your assets. And what's extremely important there is, I'll give you an example, is that with a financial power of attorney, you give somebody the ability to control your financial affairs for you. There's a situation I know of where an individual, his parents went off to Europe on a month-long vacation. This individual needed money to start up a business. He was the attorney in fact for his parents. While they were in Europe, he sold their personal residence. Now, I know that's an underhanded thing to do to somebody. Of course, you come back from a European vacation, you come back to your house and you find another couple living in it. You may think that you've fallen down a rabbit hole, but in this case, the guy had actually sold the house. The parents gave him that power. Now, granted, he took that money and put it into his business and he made them millionaires, but still, that's a wound that's probably never going to heal because he violated their trust. Well, if you have a living trust in place, that would never happen because a living trust would prevent somebody from making those types of decisions without your acceptance. If it's not in the trust document, they could not do that. So a living trust operates immediately, provides immediate protection for you. It also provides typically for the custody of minor children. Many people that I talk to that have estate plans in place haven't even thought about how they're going to hold the assets for their minor children. Or better yet, consider this. You nominate somebody as the guardian of your children. What most people do not consider when they nominate a guardian is what type of financial burden will that place on that couple with whom you've nominated to take care of your children. Recently, I worked with an individual, and she wanted her 2 children to go to a close family friend. Well, that close family friend happened to have 4 children of their own. And when I discussed this with my client, I said, not only do we want to give them money on a monthly basis to raise their children, but we might want to consider providing them some other type of stipend so that they could expand their house, so that they could get a larger vehicle, possibly a van, in order to cart all the children around, because you're imposing upon them a significant burden there where they already have 4 kids of their own and they live in a 3-bedroom house. Where are these other 2 children going to reside? It's going to require either we buy a new house or they add on to their existing house. So in that estate plan, we set aside monies to ensure that they could upgrade their vehicles and they could upgrade their house if they wanted to serve as a guardian of this person's 2 children because of that burden. So just merely naming somebody in and of itself is not oftentimes enough. You need to think through the process there and the family who's going to take that child on, what might they need? Privacy. With a living trust, you've bypassed probate, so none of your dirty laundry, if there is any dirty laundry there, none of your assets are exposed to the general public because it bypasses a probate process. Because in probate, you have to report back to the court. You have to give them the accounting of the assets. You have to put the will on file so they know who the beneficiaries are and I know how much they're going to get. That's all available. With a living trust, it's not going to be made available because there's no probate filing. Control over distribution. That's a big one. So you can decide when and where and how the children are going to receive the money. I think that's extremely important, as I'm going to be talking about here in a little bit, when you have, assets that you want to leave to your children, and maybe there's a spouse that you don't necessarily get along with. How are you accounting for that? And that's why, you want to make this a conversation, not only between you and your spouse, but also bring your children into it so they understand that any plan that you're creating is consistent with their wishes and that it will flow accordingly. So a trust is by default set up to give you a tremendous amount of control over how your assets are going to be distributed to your beneficiaries and in which manner they're going to receive them. Many times with children, I typically recommend that people set it up so that the assets are held in trust for educational needs. Or if they have grandchildren, put together an education trust for the grandchildren. Not only do we want to pay for their college or help them out, maybe incentivize them to get good grades. And then you can also add in provisions if you're concerned that they may take a wrong turn in life and they develop an alcohol problem or a substance abuse problem. You can put provisions in there to have them tested to ensure that it doesn't become a problem, that the funds can be used to help them get treatment. So we don't pay them money to support a habit. So there's so many different things you can do through a living trust. Minimize family disputes. This is one of the most important aspects of the trust, because what I see this clause doing is ensuring that you do not have family members that see the passing of a loved one as an opportunity to enrich themselves. I use the example of my uncle who charged $70,000 to administer my grandmother's estate. Well, I can tell you this, had there been a trust in place, that would not have happened. Because when you draft a trust, what I suggest people do is they put in there a provision that limits the trustee's compensation. You can limit it to an hourly amount, you can limit it to a monthly amount or an annual amount, or you do some combination thereof. For example, maybe you put in there you're entitled to receive $50 an hour and not to exceed $5,000 per year, in no more than $12,000 in the aggregate. So now this person who is administering the estate, there is no incentive for them to prolong it out any longer than possible because they're not going to get paid. They cannot take any money out of it beyond that cap. So this, I found, is a very effective way to minimize disputes among family members when they look at one child or one sibling who is handling all the affairs and then paying themselves to do it. Or you can put in there that they're not entitled to receive compensation. It's not unusual for me to draft estate plans where we state that if you're a family member and you're serving in this role, you're not entitled to receive any money. So this is really important. One other thing to consider when dealing with estate plans, if you have children, who do you set as your trustee or your executor? I'll find a lot of people tell me they'll choose the eldest son or the eldest daughter, the eldest child, basically. Now, that could be a problem because if you have 2 children, 3 children, the other ones feel like they're on the outside and they're being dictated to by this one child. So I'm a very strong proponent of including all the children in the decision-making process. If they choose not to participate, that's up to them. But you've shown that you trust them and that they can work together in bringing your estate to a resolution. And so considering who your trustee is probably one of the most important aspects of your living trust, because that person who's going to be in control of it must share your same values, of course, and be willing to accept that position and feel like they're included in the carrying out of your wishes. So how does a typical trust work? Well, I talked about it as a box. So you have this box, you have mom there, you have dad there, your trustees, your beneficiaries. It holds all of your assets. And then when one spouse passes away, let's take dad out of the picture, the typical joint trust will divide. And this is done to ensure that we've minimized estate taxes to the greatest extent as possible. And it'll divide into 2 trusts, and both of these trusts will be run by the surviving spouse. And it'll pay income to the spouse, and it'll pay the principal to the spouse, but we're making sure that each spouse has maximized their current estate tax exemption amount. So here, each spouse can pass on $5.3 million free of any estate tax. And then when the surviving spouse passes away, the assets will come together and then be distributed to the children like this. Now, it's very common. This is how most trusts that I review are set up. It's a straight division. If we need to divide the assets to minimize estate taxes, and when the surviving spouse passes away, the assets get divided amongst the children. Now, that's fine, but there's a number of things here that are often overlooked in this very simplified design. Yes, you have achieved the benefit of bypassing probate, but the problems are that you may have inconsistent desires with those funds. And what do I mean by that? Well, let's take this same example again. So we have both trusts now, like I previously showed you. We have the A trust and the B trust. Mom's in control of them. And then mom's going to pass away and the assets are going to go to the children. But what happens if the son dies without an estate plan? What's going to happen to his assets? Well, in that particular case, the son, without an estate plan, the assets are going to go to the spouse. Now, this may be a problem because this spouse is someone that you didn't intend to receive the money, and as a result, they received, I think we get cut off here. As a result, the money now bypasses your children, or your grandchildren, that is. It goes to the spouse that you may not have anything in common with. You didn't want them to receive the money, and then it completely has frustrated your entire estate plan. So that is a real problem. Now, there's a really easy way to solve that, and that's by making sure that when you set up your trust that you hold the assets in trust for your children and you don't give them everything outright so that you don't have to worry about assets being diverted if they failed to plan. So what I really like about this unit trust is that you can set it up so that you can ensure that your kids are going to receive a set stream of money for their lifetime. Typically, you can set your payout. Maybe we set it up where they're going to receive 8% of the assets for a set period of time. And then when they pass, those assets would go to their children. Or you could have it set that, it'd go to your child, and then maybe you want the income paid to his spouse if you do have a good relationship with that spouse. But then the monies won't be diverted. That is, they wouldn't be diverted if the spouse got remarried to another spouse, because they're always going to be held within your family line. Here's an example of how that might work out. Let's say you had an estate valued at $5 million. Your child will receive $400,000 each year. The way we set up a unit trust amount is we take the value of the trust and we multiply it by the unit trust payout percentage. In this particular case, 8% amounts to $400,000 a year. I don't know how many kids could not survive on $400,000 a year. But the purpose of this trust, of course, is to preserve wealth, to ensure that it gets passed on to future generations, and that if something happens to our child, it doesn't automatically or possibly get diverted to someone that we never wanted the monies to be passed on to. So another benefit of setting something up in a unit trust is that it provides asset protection for your children. So if they go through a divorce, those funds would not be diverted to the divorcing spouse. It provides or preserves wealth for your family, that it can be passed on to multiple generations. So protecting against possible lawsuits and against possible remarriages, that's all part of creating a unit trust. And many estate plans don't even consider this. That is, they want to leave everything outright to the kids, and then it's as if, I don't care what happens after that. Well, part of setting up an estate plan, being a parent, in my opinion, having raised now two children, well, actually I'm raising them, one's 15 and one's 17, is that as they mature, they still lack certain aspects, of course, when it comes to maturity. That is, they don't understand the consequences necessarily of their actions, and they always think they do. I have a 17-year-old right now, and he thinks he knows everything. That does temper with time, but still, when you set up a unit trust in this manner, you ensure that your wishes will always be carried out, and you're protecting their interests as well, even though sometimes they may not see it. Other problems with estate plans: state death taxes. Everybody talks about federal estate taxes, but you may not know this, but your state can also tax you. That is, the place in which you pass away and the state in which you die in, if they have a state tax, you will have to pay taxes in that state. And here's something else, that if you have two residences, then estate taxes can be a portion that you'll have to pay taxes in two different states. So you need to really consider what is the impact of the state on your estate in addition to the federal government, because these limits are oftentimes much lower. That is, you can pass more on and avoid federal estate tax, but not for the state in which you're residing in. Here's a map of the states and what they charge, or what their limits are, or how much you can pass on free of any estate tax. I live in Washington State, and it's at $2 million. After that, there's an estate tax that kicks in. Even though I don't have to pay anything to the federal government, Washington State will still tax me. So I've broken these down for you here. The federal limit right now is $5.3 million. That is how much you can pass on without there being any tax. But if you happen to reside in any of the estates you see on this screen right now, you'll see they have a lower threshold amount where an estate tax will kick in. Here are some other states: Massachusetts, of course, starting it off, down to Washington, different amounts. Look at New Jersey, $675,000. New York's only $1 million, as are several of the states on this list. Now, I wouldn't consider, if you didn't see your state on that list, that you're safe, because this is a tremendous opportunity for states who have budget shortfalls to go in, reenact a state estate tax in order to generate revenue when their residents pass away. California is a huge one. I mean, they have one of the largest budget deficits in the entire country. Where do you think they're going to find revenue to plug that? Well, they have a lot of millionaires that live there, so why not tax them when they pass on? There's an opportunity, so you need to ensure that you're planning around that your trust addresses not only the federal estate tax, but also the state in which you reside in, any tax they may apply against your estate. You want to protect your wealth for future generations. I gave an example of what happens if the money is passed to your son, he passes away, and then it goes to a spouse. Well, one way to protect it for future generations is to ensure that you've set up possibly a little different type of trust, a generation skipping trust. And what I mean by that is that you don't necessarily want your estate to go directly to your son, directly to your daughter's trust, because maybe one of those children, they already have a sizable estate. And by giving them the money outright, all you're going to do is increase the estate taxes on their estate. So one option, rather than setting yourself up in that type of situation, where you're going to take your son's estate and increase it to $12,500,000, which pushes him over the federal estate tax level, which when he then dies would leave your grandchildren with an estate tax bill of $833,000, is to think about this a little more closely. That is, in this particular case, the child has plenty of assets. They do not need those funds. So why not bypass them altogether, but do something where we create some type of safety mechanism in there? The way we do that is with a GS-compliant bypass trust, which is called a generation skipping transfer trust. Now, how this works is that when you pass away, rather than leave it to your son and daughter outright, instead you'll give it to your daughter in this particular example, because her estate is under that amount that she could pass on to her children free of estate tax. But you create your living trust would create a separate trust just for your grandchildren and, of course, your son. We're not going to leave him completely out with that money, but we'll create this trust that provides that while your son is alive, the income from this trust will be distributed to him for his life. Then when he passes away, the assets that remain inside of that trust will go to your grandchildren. So anything that's left inside of there is for your grandchildren. Now, by making this one shift, rather than giving your son the full $2.5 million and adding that into his estate, we gave him the benefit of the money, but made sure that the gift was actually a gift to your grandchildren. So it won't be taxed when your son passes away because it's not included in his estate. This amount of money bypasses his estate for federal estate tax purposes. And as a result, you'll find that your children now have saved $833,000. And that is such a simple change to make in living trust. And it's so often overlooked because people, when they set up their estate plans, they set it up initially where everything's going to be divided amongst their children. And they never go back and revisit this and say, my child's done extremely well for himself and he doesn't need this money. So let's then give the money to his children, but not until he passes away. So his kids couldn't just spend the money right out. We could have all kinds of provisions inside of that children's trust. Maybe give them money to help them, as I stated earlier, get through college, maybe start a business, buy a house. If they're going to get married, some money to help pay for the marriage. But it's not a situation where they have unfettered access to the principal itself to spend it any way they like. They have to mature, and your son has to pass away before that's going to occur. So, another often overlooked aspect of estate planning is life insurance and how that's going to be accounted for in your estate. There's a lot of different types of life insurance policies out there: term, whole life, universal, variable life insurance. But the aspect that I'm trying to convey here is, what are the tax consequences of this? Most people don't realize that life insurance is going to be included in your estate for estate tax purposes when you pass away. Everybody has been conditioned to understand that life insurance is tax-free. Well, that means it's income tax-free to your beneficiaries. It's not estate tax-free. And if you own a life insurance policy in your own name, if you're listed on the policy as the owner of the policy, it's insured on your life, then when you pass away, even if you've designated your children or your wife as the beneficiary of that policy, the entire value of that policy will be included in your estate for federal or state tax purposes. So let's assume in the previous example, here's the son. If he had a $3.5 or $5 million policy on his life and he didn't do anything different, then when he dies, his estate is actually going to be worth $15 million. Even though the policy had his kids listed as the beneficiaries and they get the money right away, it's still included in his estate for estate tax purposes. So with life insurance, what you want to do is set up an irrevocable life insurance trust. And that helps you pay less estate tax, because with an irrevocable life insurance trust, you're removing the value of the insurance from your estate. That is, you're transferring ownership into this trust for the benefit of your children today. So when you pass, the proceeds, of course, are tax-free, because not only does the trust not pay any income tax on life insurance, but the proceeds themselves, they're not included in your estate because the policy was transferred while you're alive, prior to your passing. Now, there are some rules with regards to lookbacks, but the main point here is that by creating this irrevocable trust, you're assigning the proceeds over to the trust so that when you pass, you don't own them. They're owned by your children or your beneficiaries. This is a huge mistake that so many people make. They don't realize that the life insurance will be added into the value of their estate. And in many cases, they lose the benefit of the insurance because so much is taken in state taxes. So the other thing that why people often plan for this is, of course, because the cash itself that's held in the trust, once you have this money there after you've passed on, it's a great way to help pay for any state taxes that may be implied because your assets outside of the islet, that is the other assets you have, may be at a point where you need to cover estate taxes. Like, for example, let's say you have a lot of land. Let's say your estate's valued at $20 million and it's all included with $15 million of land. Well, where are you going to come up with the $8 million of estate taxes? You may have to sell the property in order to cover that bill. I mean, we have a client whose parents passed away in 2006, and they own a lot of property in Montana. It was valued at that time at $15 million, and the estate tax exemption at that time was about, I think it was $2 million. Well, this has drug on for a while now with our clients fighting the IRS, and the net result of this is that the property to this day is worth about $6 to $7 million, because when the real estate crashed, this property lost a tremendous amount of value. And our clients had to sell the assets basically to cover their estate tax. That is, they lost everything from their parents' estate because they did not plan properly. So when you create an estate plan, I mean, this is something you want to consider, is that how can you ensure that those assets are going to be passed on to your loved ones and not have the federal government come in and step in and make you sell everything just to cover the tax. Had they had an irrevocable life insurance trust set up, funded with life insurance, then those taxes would have been covered. So the way you do this is you set up a trust and you transfer your existing policies that you may have into this trust. Or you could buy a new policy in the name of the trust. You list your spouse and your children as the beneficiaries, and then each year when your premiums are due, you'll gift them to the trust. You just write a check to the name of this trust, and then the trust will pay the premiums on your life insurance policy. And so this is what gives you the benefit to pass on all of your life insurance free of any income tax or estate tax to your heirs. And here's visually how it works. So dad's the insured, and so each year he would gift annual premiums to the trust. The trustee of this trust would then go out and purchase a life insurance policy or pay the premiums on the life insurance policy. Now, when dad passes away, the policy is going to pay out and the proceeds will be distributed to this trust. Well, mom is still alive. So when we set up this trust, we want to ensure that mom's going to have income for life before it goes to the children. So the trustee of this trust will pay all of the income generated from the assets to the surviving spouse for their lifetime, and they have access to principal. And then when the surviving spouse passes away, that is when the assets will be distributed to the children tax-free. Now, it doesn't have to be outright. This is a trust that you can create, so you can set parameters in your trust as to when they're going to receive the funds. But this is the ideal way to pass on life insurance, to make sure that neither the state nor the federal government can tax those monies. And for many times, this is a huge source of cash for a lot of families that oftentimes gets overlooked. So, another aspect we have to look at here are retirement planning assets. What are you going to do with your IRAs, your 401ks that you've accumulated quite a bit of wealth in? Well, if you don't do anything and you keep them in your estate, look what can happen. Within a $500,000 IRA, when you pass away, not only will there be estate taxes of $225,000 in this example, but you're also going to have income taxes on top of that IRA because it has to pay out to the beneficiaries. A person who receives it has to pay income taxes on it. Or if you don't even name a beneficiary, it's paid into your estate, your estate will pay income taxes on it. So yes, as a result of this, you pay not only income taxes, but estate taxes when you fail to plan for retirement planning assets. And as you can see here, the amount your heirs actually receive after taxes is only $122,000. That's a 75% shrinkage in the value of this IRA because it wasn't planned for properly. Now, one way to plan for this is to set up an ILET to cover the taxes if that's the way you want to handle it. So you could have an ILET created. You have this IRA balance. We know what the taxes are there. What we could do instead is have an ILET. We can fund it with life insurance, and the life insurance would then be used to cover the taxes. Or you could just take those funds, those IRA funds, pull them all out now that you have an idea that you don't necessarily need. And many times what we'll do is we'll take those funds, turn around and buy a life insurance policy inside of an ILET. And then the life insurance policy will be passed on to the kids free of any estate tax or income tax. So it's liquidating the IRA early in order to buy the policy, which produces tax-free income for your family. If you don't need that money in the IRA, then that's a great opportunity for you. Hey man, I'm trying to do a recording. What's up? Yeah, and you keep calling. Can I call you back when I'm done? You're going to make me have to do a lot of cut and pasting. All right, bye. So another way to avoid the tax is to look at a completely different type of tool, and that's called a charitable remainder trust. What a charitable remainder trust is designed to do is set it up so that when your IRA is distributed into this CRT, you don't have to concern yourself with income tax or estate tax because the CRT is in part a charity because it becomes a beneficiary IRA, but it's not an immediate charity. That is, you're not giving it right away to a charitable organization. What you're doing is you're giving it to a trust that provides that when your beneficiaries of this trust pass away, then the assets will be distributed to the charity that you've chosen. So this is a great way to give your children an income stream for their lifetime without forcing them to recognize immediate income tax on the distribution of that IRA. It's also a way for you to take that full, in my example, that full $500,000, put it in there to ensure that there's a full $500,000 for the children to utilize during their lifetime to draw an income stream off of. And it's a great way to get a tax deduction because when you designate a charitable remainder trust as a beneficiary of your IRA, what you're doing is you're telling the Internal Revenue Service, the federal government, that when this trust expires, there will be at least 10% of the assets I put in there available for a charity. So if you gifted $500,000 into a charitable remainder trust, then there will be $50,000 available for that charity. So you're entitled to a $50,000 charitable deduction. That is, your estate is. So that helps reduce your estate taxes as well. So the charity benefits, that is when your children pass, your children benefit because they get an income stream for their lifetime. The only person who doesn't benefit here is Uncle Sam because there's nothing available for them by creating this type of tool. So that's another great way to plan for retirement accounts. And again, this is oftentimes overlooked when it comes to estate planning. People just designate their child as a beneficiary. They don't think what are the income tax and the estate tax implications of making that designation. Now, we talked about the living trust and the estate plan, but the question is, how do you hold assets inside of there? You know, holding assets in a certain way is so very, very important because you want to ensure that those assets are going to be there for you when you retire, when you're ready to pass on the assets to your children. But only one mistake can make everything crumble. And that is, you can lose everything by not having your assets adequately protected because a living trust does not offer asset protection. And so what I like to do with my trust is I break them up into quadrants, and I show my clients, there's different sides to your living trust on how you should hold assets. You have the personal side, which are the assets that are held directly in the name of your trust. You're not going to get any asset protection there, so if you're involved in a lawsuit, they are at risk. But then you have the safe side where you hold your investment assets, and there we can do some work. You have the dangerous side, most definitely, that need to be protected. Not only do you need to protect them from, you protect yourself from those assets, but you need to protect them from each other. And then you have any businesses you may have created during your lifetime where you have liability risk involved. So you think of your living trust as a quadrant that you have different sides to it. And in the personal quadrant, you would put all of your personal assets. Now, I'm doing this figuratively speaking. We actually don't divide up a trust in this manner because you put everything into your trust, but it's how you place those things into the box, which is so important. It's like residences, your personal bank account, your vehicles. All of those assets are put into your trust directly into the name of the trust. So if you had the Coons Family Trust, your house might say its title would be in the name of the Coons Family Trust. But safe assets like your stock account or your savings account, you wouldn't necessarily want to have those directly in the name of your trust because the trust doesn't provide any asset protection. So oftentimes what I will do is create a limited liability company to own these assets. So if I'm involved in a lawsuit, my savings, my brokerage account is protected from my personal creditors. That is, with the LLC, they can't take that LLC from me, so they can't jeopardize my retirement planning years by taking the assets that I intend to rely upon. So that's one aspect of it. So your LLC would be held in the living trust. Then in the dangerous quadrant of my trust, I look at the assets there that produce liability for me. Those types of assets most definitely would be any rental real estate that you own. Here, you want to ensure that you do not have these assets titled directly in the name of your trust because if anything were to happen with any of these assets with a tenant, then they could sue you personally and all of your assets would be at risk. So with these assets, we will put them in separate little boxes. And those boxes are designed to contain the liability that these types of assets generate. Here, what these will be, of course, would be limited liability companies as well. It's a great tool for holding rental real estate. And what we've done now is separated out the liabilities from each asset. So if anything happens with the first house, the building and the second house are completely protected. You're protected from whatever happens inside of those boxes. So if a tenant brought a claim for environmental contamination, they sue the LLC, but you're not the responsible party. It's just the assets held in that one box. Or vice versa, your child does something wrong and is involved in an accident and they sue you. They couldn't take your rental real estate from you because the LLC prevents that from occurring. So dangerous assets need to be in their own quadrant in your trust in separate entities that provide you with asset protection. The last quadrant would be your business. This would be something that you're running. Maybe you're a real estate investor or flipping properties. Maybe you have a pet clinic. Who knows what your business may be, but that should be in its own separate entity inside of your trust so you have liability protection. So liabilities associated with that business will not bleed over into your personal assets and make them responsible for the debts and obligation of your business. This is typically going to be a corporation. And I often tell people that, businesses should never hold a lot of assets. If you, for example, have a building that you utilize for your business and you happen to own that building, the last thing you want to do is own that building in this corporation, because if something happens to your business, then that building is now an asset that could be taken. So what you'll do here is typically create an LLC and then take those dangerous assets, which would be the building, and lease them over to your business. That would be the best way to protect it in this scenario. So that we've taken our living trust now and we've taken what we used to be a pool of assets and we've broken them up into separate distinct units. So you really need to move from a scenario that looks like this, where you have a living trust, it's you and your wife and you own everything in the name of it, whereas just one thing could occur and everything could then crumble and you lose it all. So what is the next step here? Well, if you'd like to schedule a free consultation to discuss your plan, call this number on the screen, 253-981-6007, and my assistant will schedule a time for us, if I'm not available, one of the other attorneys in my firm, to discuss your estate plan with you, where we'll go through the quadrant like I just drew out during the presentation. We'll talk about different ways to plan for your estate. We'll address some of the concerns that you have and tell you what you could do today to ensure that your assets are passed on tomorrow with the least estate taxes in the most efficient manner as well. If you prefer to email, you can email Deborah Lewis at alglaw.com and just put in there that you would like to set up a free consultation, and she will contact you to schedule a time as well. So you have two options here in order to reach us. Now, if you're one of the people that are on this call right now and you are interested in setting up a consultation immediately to help you to move forwards, to set up this consultation, I will provide you with a free copy of my book, Asset Protection for Real Estate Investors. I will send you a signed copy of my book just as a way of saying thank you for taking action, because it's really disheartening when I see people that know they need to create an estate plan. They know they need planning, but they think, you know what, I'm going to put it off until next week. Things happen in life. You cannot predict your passing. I mean, you could set it up, but we don't want to, of course. So the thing is, you need to take action now to ensure that your loved ones are protected tomorrow. So if anybody that calls in the next 48 hours, I will provide them a free copy of my book. It's just my way of saying thank you for taking action. So with that, I want to thank you. I hope you learned something during this presentation and you got a better understanding for how a living trust works, the importance of asset protection, and I wish you the very best in life and with your planning.